Yes, Mr. President.
My Lords, I was just going to spend a little bit of time finishing off on the warranty appeal point, but not long.
By all means.
And this is on really the question of what it means or whether the amount claimed was notified and whether the calculation of the amount claimed was notified in reasonable detail. And so one way of asking that is to remind oneself that it is not just talking about providing a figure, but it is talking about providing the amount claimed. So even before one gets to questions about reasonable details of the calculation, the very least that you have to do is to identify the amount. But when your Lordships go back to paragraphs 40 and subsequent of the Notice of Claim, what one actually finds is that there is not a figure given for the amount claimed. And the reason for that is because what is in fact said in the Notice of Claim is that the losses are yet to crystallise. So there is no present amount that is claimed. All there are figures that can be given, which may or may not amount to sums that may be claimed in the future. And that makes a difference when one is asking the question, has the claim that is being made through the amended particulars of claim, has that been notified? Because that is a present claim where the loss was incurred at some point at or after the entering into the SPA. And that is the amount that would have had to have been notified in order for the amount claimed, that is to say in the diminution in value claim, for that to have been properly notified. And of course they made a choice. They chose not to notify that claim. They chose to notify the different claim about future contingent losses. But if one is simply looking at the language of the provision, there has not been an amount claimed for any present claim that is being made, and that is what is required for the claim advance through the amended particulars. But even if one could say, well, in some way an amount has been identified, one goes on to consider that there has to be reasonable detail of the calculation of the amount claimed. And so, again, we say no, although what you have there is a calculation of the future estimates of amounts that may arise, what it is not a calculation of is a calculation of a present amount that is being claimed. And it matters not that Malone and Friends says, well, you could, if you were a skillful lawyer, anticipate how you might get back to a diminution in value claim if you were making one. Because what is required is a calculation of the amount that is being claimed. And in order to do that, what you would need to do after saying the loss is yet to crystallize, or here are our future estimates of losses that may arise, the calculation would necessarily require some explanation of how one gets from that to arrive at a figure for the reduced value of the asset that Drax acquired. And that is what is entirely absent from this Notice of Claim, and we say to be inferred deliberately so because they chose to put their claim in a different way. But what that means is that there is, we would accept, a breakdown of certain figures, But what it is not is a calculation of an amount claimed in the form of a present claim of the kind that is being pursued in the amended particulars of claim. And another way, or another prism through which one can look at this, is to say that both identifying the nature and identifying the amount and calculation of the loss require reasonable detail of how the loss has been caused. And since you can only establish causation on the basis of the loss measure that one is adopting, one can only do so, satisfy that causative element, by explaining the calculation in terms of warranted value and true value. You told us it was worth X, it turns out it's worth Y. And so that is one way of summarising why we say the judge was entirely right. Unless I can assist your lordships further on that point, that was what I wanted to say about the warranty.
Thank you. No, I think you're going to carry on actually and open your appeal, and then so we didn't have multiple speeches.
Forgive me what I misunderstood. So on to the indemnity. So there are two short questions of construction, one in relation to the demand point, the other in relation to the timing point. I will go through the judge's reasoning, obviously. Before doing so, it's worth looking at the relevant provisions afresh and summarising how we say one should construe them. Once I've done that, I'll go to the judgment and explain where, with respect, we say the judge went wrong on this point. And after that, I'll elaborate a little on our basic case and respond to some of the additional points made through Drax's skeleton. And of course, we have to succeed in relation to both the demand point and the timing point in order to succeed on this appeal. There's little, if any, disagreement about relevant principles. We don't say the judge misdirected himself about the law. This is just one of those cases where they've been misapplied. And so all of my submissions are back to the central and common task of focusing on the words of the bargain, determining objective intentions, iteratively testing by reference to different interpretation, different provisions.
Well, is this a case where you say the language is ambiguous?
My lord, no. In my submission, the language is sufficiently clear, and if there is any ambiguity, using all of the tools that the court has to resolve those questions of ambiguity, they are easily resolved in my submission. Which is not to say, well, when we come to the timing point, I'll explain quite what I mean by that. So, my lord, can I begin then with the demand point? So, starting with that, the question is: did Drax have to make a demand for payment under Clause 11 before it notified a claim under Clause 11? To answer that, one has to answer two sub-questions. First, what has to be notified? And so if we go to paragraph 2 of Schedule 4, at page 101 of Supplement 1, and this is all under the heading Time Limits for Bringing Claims. And the word claim appears 4 times in the opening words, and you'll see that the way it works is that the seller is not liable for a claim unless the buyer has notified the seller, and then we have the requirement of reasonable detail that we've been over in the context of the warranty appeal. And then we have the various types of claim set out, and you have 2.1.1 you have relevant claim, 2.1.7 you have reorganisation indemnity claim, to which we need to add a further category that was added by the deed of variation, which is at supplement 3, page 230. Which you will have seen, I'm sure, this is the first deed of variation that we're looking at, and there was a new definition specific to Damhead Creek 2. This is the Damhead Creek 2 option agreement claim, and you'll see over the page at 3.5 we have the addition of a wholly new category in respect of any Damhead Creek 2 option agreement claim on or before the date, which is 24 months before from the completion date, and that was later subject to the second deed of variation to make it 30 months. And I'll obviously come back to those in more detail on the question of the timing point. Now, but just going back to the opening words of paragraph 2 of Schedule 4, there are some fairly obvious points to make about this language. First of all, we are not concerned with a possible or potential claim. And in fact, as I mentioned, or may have mentioned, paragraph 5.1 of Schedule 4 it is a clause that is to do with possible or potential claims, because there's a provision about bringing to the attention of the other party matters that may be the subject of a claim. But paragraph 2, which is what we're concerned with, it is only about actual claims. And we're not concerned with claims that are subject to contingencies or conditions and so on. And the only qualified exception to that is paragraph 8 of Schedule 4, which has a specific provision in relation to relevant claims, which the indemnity claims are not part of, where if that claim is for a contingent liability or is for something that is otherwise impossible to quantify, then you still give your notice, but the issuing of the claim in court is deferred. So subject to that, what is required is nothing less than notice that a claim is being made. Second, we're not concerned with claims in general, we're concerned with these particular types of claim. And it follows from this that in order to find out what is required to make each type of claim, one has to look at the definitions of that type and ask what must be fulfilled in order to make that claim. The fourth point is that the reasonable detail provisions that we've been looking at in paragraph 2, they rather underline the point that this is going to be the claim, that the claim will be for an amount, since the amount is something that has to be notified. Reasonable detail has to be given about it, including the calculation of the loss. So that rather underlines the requirement of the amount. So the only answer we submit to the question, what has to be notified, is that a claim has to be notified. The second sub-question is, what does Drax have to do in order to have a claim under clause 11.1? And if we go to clause 11.1, which is supplemental bundle, page 1, tab 1, page 25. This is the definitions, but you see that a reorganisation indemnity claim means a claim pursuant to clause 11.1. And then if we go to clause 11.1 on page 50.
Sorry, you're ahead of me. Reorganisation, what?
Forgive me, it's page 25. Yes. It's the definitions of supplemental bundle tab 1.
No, what is the definite? Oh, reorganisation.
Reorganisation indemnity claim. Yeah.
Sorry.
So that means a claim under clause 11.1. And then if one goes to page 52, we have clause 11.1. And this covers a variety of different reorganisation indemnity claims, but the ones that we are concerned with are identified in 11.1.3 and 11.1.4. But again, the language is very simple and very clear. The seller covenants to pay the buyer.
Sorry, where?
This is at the opening words of 11.1.
Yeah.
Subject to completion and clause 11.2 and 11.3. The seller covenants to pay to the buyer.
Mm-hmm.
Each group company and each other buyer's group undertaking. So there's a covenant to pay within 5 business days of a demand by written notice from the buyer to the seller. An amount equal on an after-tax basis to any and all losses suffered by any group company. So, and then if we pick up at 11.1.3 and 11.1.4, those are requirements that it has to arise, the loss has to arise in relation to the implementation of the reorganisation, and has to be something that would not have arisen if it had been, if it hadn't been carried out incorrectly. So we say the answer to this second question is straightforward. First of all, you have the causative question. The group company must have suffered losses relating to implementation of the reorganisation. And second, Drax must have demanded from Scottish Power payment of an amount equal to those losses. So the way in which 11.1 works is that there is no claim, there is no obligation to pay anything until after the demand for an amount equal to the losses has been made. And that's obviously the result of the language employed, but it's also the logical consequence of an obligation to pay a specific amount. Scottish Power can't be under an obligation to pay anything unless it is told what amount is demanded from it. And so,
I mean, why is this about claims at all? Why is this not a covenant to make a payment, an agreement to make a payment within 5 days of a demand?
Well, it's described in the SPA as a reorganisation indemnity claim. Your Lordship is right that it is a promise. In the way it's expressed, it's a covenant to pay a certain amount under certain circumstances within 5 business days after a demand. But really, one can take away the word indemnity and just look at how this operates. In order for there to be a claim, so a reorganisation indemnity claim is a claim under clause 11.1. In order for there to be a claim, there has to be a demand.
But this clause doesn't mention the words reorganisation indemnity claim.
No, that came from the earlier...
No, I understand where it came from, but it's not mentioned here.
No. But the reason why I refer to it is that in paragraph 2, when one's looking at time limits, you have the definition reorganisation indemnity claim as a type of claim in 2.1.7.
Is a claim the one that happens if you don't pay, or is a claim the one that happens after you've given notice to pay before you're due to pay?
Well, there's a question that doesn't arise, which is it sufficient to have made the demand, or do you have to wait for the 5 days to elapse? Well, technically, one would say wait for the 5 days to elapse, and then there is then you have a claim, because then there is an obligation to pay. It doesn't arise, as I say, on this particular case. But so so our basic case is that the judge was wrong on the demand point. You have to make a demand in order to have a claim. What you're notifying is claims, and therefore you had to make a demand before any notification could be made. Could we just
Sorry,
look
just
then
do
at
that
the
again.
judge's...
You have to make a demand to have a claim, so
and therefore, in order to notify a claim, there has to have been a demand, because what you're notifying is a claim, and you haven't got one until you've made a demand.
and you notify under 2 and make the demand under 11.
Yes. I was going to turn to the judge's reasoning to just see how the judge reached the conclusion that he did, which is obviously contrary to what I'm submitting. And so at page 136, paragraph 112 of the judgment, first of all, the judge identified the issue, whether Drax had to identify an ascertained sum for the purposes of its indemnity claim within the time limits set out in paragraph 2. And then he identified 2 questions. A, do the requirements of paragraph 2 of Schedule 4 apply to a demand by written notice under clause 11.1? And B, did paragraph 2 of Schedule 4 to the SPA require identification of an ascertained amount being claimed in respect of the indemnity claim? So, just dealing, and then in paragraphs 114 to 115, 113 to 116 deals with his question A, and I'll deal with that first if I may. 114 to 115 is dealing with the wording, 116 is dealing with commercial consequences. And so what the judge says is that the time limits don't apply. There are 2 requirements and they are independent. The first in clause 11.1 requires the demanding of an ascertained sum by written notice. The second requires a notice of the claim, stating in reasonable detail the nature of the claim, the amount claimed, etc. They are 2 separate requirements. And this is one of the parts of the judgment that we, with respect, say is very difficult to follow. So unpacking the reasoning, what the judge is saying is that the requirement for the demand and the requirement for the notice are separate. We don't disagree with that in as much as they appear in separate provisions. The judge points out that there are specific time limits for the notice but not for the demand. Again, we don't disagree that 11.1 doesn't give a specific time limit for the demand, but we obviously disagree that it doesn't impose, that the notice requirement doesn't impose the relevant time limit. Then if we go below, it says, the judge says there are specific time limits in respect of the second of those, that's the paragraph 2, as set out in paragraph 2, and a notice needs to be sent before the relevant time period expires. There is no such time limit in relation to the demand required by clause 11.1. What it appears the judge has done in this paragraph is to treat the demand under 11.1 as separate from a claim under 11.1, seemingly to treat the claim as arising before any demand has been made. And as I've said, that's incorrect, because the obligation to pay under 11.1 only arises after the demand. Prior to that, the most one could say is that there's a possibility of a future claim, but it can't become an actual claim until the making of a demand. And so, again, we say, once it's understood that in order to have a claim you have to make a demand, it makes no sense, you cannot notify before making a demand, because you wouldn't be notifying a claim, and that's what you have to do. And paragraph 3 of the Schedule 4 also sort of underscores that what we're talking about here is claims. So perhaps I should just mention that. This is the paragraph that imposes the 6-month time limit after notice for actually issuing the claim. And you'll see again there that there's multiple references to claim in that paragraph, without any reference to any further step or contingency that has to take place between notifying and issuing the claim. And so it just underscores the point that what the parties understood was that what was being notified would be a complete cause of action such that a claim could be issued for it. So pausing there and returning to the judge's reasons, the point that seems to have weighed with the judge is that there's nothing in paragraph 2, schedule 4, that expressly refers to the time limit for making a demand. And that is true only in the sense that paragraph 2 does not contain the word demands. But it overlooks the fact that a demand is necessary for a claim in the first place. And what seems to have gone wrong is that the fact that a demand is a necessary precondition for a claim seems to have been overlooked by the judge in his reasoning, even though he agreed, and it was common ground, that it was a precondition. So if one looks at paragraph 110 of the judgment on page 136, the judge refers to Drax's position there. Drax did not seek to rely on its original pleading, nor to contend that there was no requirement for a demand for an ascertained sum as a precondition to a liability to pay under clause 11.1. And similarly, in paragraph 117.4 on page 138, this is dealing with, when he's dealing with his question B, he says the fact that clause 11.1 required a demand of an ascertained sum before liability arose under the indemnity does not mean that in identifying the amount claimed and so on. But the material point is the words I've just read out, which is that the judge agreed that making a demand was a precondition to liability. And so we do say that in this part of the judgment there is an illogicality, because the only way he could have reached his conclusion is on the basis that a demand wasn't necessary when in fact it was. So that's what I wanted to say about our basic case on the words there. The judge also referred to considerations of commercial purpose in paragraph 116. And the 2 points that the judge, that weighed with the judge, were the potential difficulty of precisely ascertaining the sum demanded if you had to make a demand before notice. And secondly, the risk that if the amount was wrong, then Drax would be left unable to claim anything. I should say at the outset, this in our submission is not the sort of point that is going to be affected by considerations of commercial reasonableness. This is the kind of point where the words are absolutely clear, and one doesn't need to go much further than that. But the points that weighed with the judge on commercial reasonableness in our submission are not good ones. Although the judge refers to precise ascertainment, that's of course not what 11.1 requires. It requires notification of the amount. Necessarily, this is just the amount that Drax alleges constitute the losses. So precision is required. It has to be in the sense that it has to be a specific sum, but it doesn't mean that Drax has to be in a position to say definitively that this is the amount of the loss. And of course, where the group companies incurred expense and the amounts are known, there's really no difficulty about just identifying what the amount would be. Alternatively, the group company might have suffered a loss but not yet know the amount of the costs incurred. Again, there's no practical difficulty. Drax performs its best estimate of what the losses are and states them in its demand and demands payment. And of course, that might be challenged. The court might reach a different view if agreement can be reached, but it doesn't prevent the making of a demand. and even if there was some genuine inability, in considering questions of commercial reasonableness, the reorganisation indemnity, that's not the only remedy that's given by agreement to the parties. They've got the warranty claims, they've got claims under clause 14.51.3, the procuring obligation in relation to the Damhead Creek option agreement. So there are other means by which they can make their claim. And no problems of this kind actually arise on these facts, because according to Drax at least, it had already suffered a loss, and therefore it could identify an amount. As to the second point that the judge weighed with the judge, it isn't right to say that if Drax got the sum wrong, then that meant it could recover nothing. If there were a dispute, then the court would have to judge what the true losses were. And suppose Drax demanded £8 million, but in fact the true losses were only £6 million. Well, the whole of the £8 million has been notified. They could recover the £6 million. So there isn't a difficulty there. And as I've said,
does it work the other way around? If they notify 6 but can prove 8, do they only get 6 or do they get 8?
I think they only get 6 in that case. But again, it's in my submission, it's not a difficulty that you only get what you up to and including what you notify, because that is the bargain that the parties have reached for this particular mode of loss, or mode of claim. And that's why I go back to the point that the claim under clause 11.1, I'll perhaps call it that rather than the indemnity claim. The claim under clause 11.1 is one of several claims that are types of claim that are given to Drax, arising specifically in relation to the reorganisation. And so your lordships will have seen the warranties that were given under section 9.1 and 9.3, or paragraphs 9.1 and 9.3, which were essentially warranties that the reorganisation had been completed in accordance with the reorganisation documents, and the express obligation at clause 14.51.3, which is a procuring obligation to ensure that the option agreement is transferred. If one compares those to the circumstances in 11.1.3 and 11.1.4 that give rise to the clause 11.1 claim, one can at least say that they are very broadly overlapping. Essentially, in most cases, you're going to have a claim that you can make in one of 3 ways, arising from the same facts. And of course, it may be the case that there are differences between the way in which those particular claims are formulated. It may be the case that there are differences in how you can recover, but that doesn't give rise to commercial unreasonableness. So the fourth point that I wanted to make, still on this sort of question A that the judge posed for himself, is to look at paragraph 8 of Schedule 4. This is Supplement 1, page 105. And this is the paragraph that I was showing your lordships under the warranty appeal. Because this is relevant in relation to this point of the judges for two reasons. It's a provision that only applies to relevant claims, so it doesn't apply to clause 11.1 claims at all. But what it does for the relevant claims is it specifically provides for a scenario where loss is contingent only or incapable of quantification. And you have the mechanism where you still have to notify, but the 6-month period for issuing the claim is deferred until after you've suffered the loss. And so what that shows is that the parties thought about what would happen if there were a breach, but no amount could be specified. And they agreed that a warranty or a section 14.51.3 claim could be notified in those circumstances, so there was no doubt that some substantive remedy would be available. But they did not think it was appropriate to make any exception for the clause 11.1 claims along these lines by allowing them to be notified without a demand having been made. And so what this provision makes clear is that there's no commercial unreasonableness arising if, for any reason, a demand can't be made within the notice period, because there are other types of claim that are expressly deferred in when they can be brought. And secondly, where the parties intended to allow notification without the amount being stated, they expressly provided for it. My Lord, at the risk of overkill on these, what I say are second order points that influence the judge about commercial unreasonableness, that there is a fifth point, and that is that the considerations that weigh with the judge on reasonableness are on analysis inconsequential because at most they relate to a 6-month period. And the way that works is that paragraph 3 of Schedule 4, which we've already looked at, requires that the claim has to be issued within 6 months. And so the issue that the judge identified was, well, it's unreasonable to expect somebody to make a demand in the period given for notice because they may not know. But by the time they issue their claim, there's no choice. They've got to say what they are claiming for. So at the very latest, they're going to have to have that amount 6 months after the notice is given. And so that rather shows that if they were going to have to do it within 6 months after the notice point, it can hardly be said to be unreasonable. So we say that the clause 11.1 claim under the Damhead Creek 2 subject matter is 30 months. So if it wouldn't be unreasonable to expect them to have a figure within 36 months, it can't really be said to be unreasonable for them to come to a figure within 30 months. So, well, that brings me on to the second question that the judge asked, which is, even if the demand was not required to be made before notification, that he went on to consider, well, do you still have to give the amount in giving the reasonable detail of the claim? So this is a question that it's really only relevant if your lordships concluded that the judge was right on the first point, his first question A that I've been dealing with. If the demand is a precondition of the claim, then the demand has to predate the notification of the claim, regardless of what details the notice is then required to state. But in actual fact, if you look at the reasons that the judge gives, we respectfully submit that they aren't good reasons. And in fact, we say that they rather reinforce the point that we make that demand is a necessary precursor to notice. So paragraph 137 at the bottom is, paragraph 117 on page 137, the judge deals with this question B, and he sets out over the page, he sets out four subparagraphs. And just to summarise what they deal with, first of all, he distinguished reasonable detail from full detail or precise amount. That's sub 1. Sub 2, he observed that Scottish Power understood what was being claimed against it. Sub 3 refers to uncommercial results. Those are the ones that I've just been addressing. And sub 4 acknowledges that there might be some circumstances where reasonable detail entails giving the amount, but this wasn't one of them. Just going back to what the judge referred to, he referred to reasonable detail, but that was all that he highlighted. So what in this particular section, what the judge did not do is repeat the whole relevant bit of the provision, reasonable detail of the amount. And really here, it's the basic information of notice requiring statement of the amount that is the critical question, because that can only be done by notifying a figure. And so the judge's reasoning about whether reasonable detail required statement of an amount wasn't really addressing, in this section, the operative language of paragraph 2 in its specific reference to an amount. And we do also say that the requirements for the contents of the notice underline the basic construction point, which is that the parties agreed that stating the amount claimed was a precondition of valid notification. That included clause 11.1 claims. And the obvious reason for that is they knew and understood that in order for there to be a clause 11.1 claim, there had to have been a demand and thus an amount. So on the demand point, I'll just deal briefly with some of Drax's arguments. If we go to Drax's skeleton argument, this is a core 6, page 92, paragraph 19.
Which paragraph?
Paragraph 19.
I don't think it's core 6.
Core 7.
Oh, I'm so sorry. Cool. I've given you about it. Core 7. Core 7, I'm told. And so what they say in paragraph 19.3, they say D's obligation to pay the indemnity arises upon the making of a demand. But they go on to say, however, it is possible for C to have a reorganisation indemnity claim and to give notice of that claim before any demand is made. And the reasoning behind this seems to be paragraph 20. They say that in the third line, a liability, whether contingent or prospective, to indemnify C arose at the time of completion of the SPA, for the reasons given. And then they say from that point onwards, C had a reorganisation indemnity claim and was able to notify D of that claim. What they seem to mean by C had a reorganisation indemnity claim is that Drax had the ability to make a claim against Scottish Power, contingent only upon first making a demand. And that perhaps explains the reference to contingent liability, so that what seems to be said is the highest it can be put is some form of contingent or prospective liability prior to demand. But in relation to that, all that means, if you describe it as a contingent liability, in other words, there would be a liability if you made a demand and waited 5 days, that isn't a claim. That's a potential claim that might be made in the future, but it isn't a claim, and it isn't right to say that C had a reorganisation indemnity claim at any point before it made a demand. And of course, what is required under paragraph 2 is notice of a claim that is being made. One certainly could not suggest that any form of claim is being made until the demand has been made. And of course, one does sometimes find contractual terms that make a distinction between the term that imposes the obligation and the mechanics for making payment. So one can think of delivery of goods where payment is due upon delivery, but there are separate invoicing provisions that operate. And sometimes one can say, oh, well, the separate invoicing provisions, that's mechanics for payment. That's not when the obligation actually arises. But this is not that kind of case. Clause 11.1 is the clause that imposes the obligation. It is not a clause that refers to some other clause that creates the obligation and only institutes some sort of payment mechanism. And just dealing with some of the other points they made, really the other points that are made are all going to this commercial reasonableness point, which in my submission is not really going to affect construction here because the words are so clear. But to summarise, and I'll just give the reference, 22.2 and 22.3 of their skeleton, they say it would be arbitrary and artificial to require ascertainment of an amount before giving notice. And we say absolutely not. All that Drax has to do is either identify the costs that it has already incurred or make its best estimate as to what the losses that have been suffered actually are. And if it was somewhat uncertain about where within the range that it could go, it could notify, it could make a demand at the higher end of that range. That isn't arbitrary in its process.
Didn't Drax do that in its notice of claim? It set out what its best estimate was.
Well, there has to be a demand.
And then said, please accept liability.
There was no demand for any payment, and Drax accepts that. Drax only suggests that there was a notification by its amended particulars of claim. So the least that one has to do is actually make a demand for payment of a sum. And that was not done in the notice of claim. And it is sought to be rectified in the amended particulars of claim. The amended particulars of claim comes after the cut-off date, we say, for notification, and that's why the timing point, which I'm going to come on to, matters.
Yes, I was just sort of testing your submission.
Well,
all they have to do is give their best estimate, because it's a bit hard to square that with a demand. We can't tell you what our losses are, but this is our best estimate. Might be wrong, but we demand you pay it. I mean, how does that work?
Well, my lord, perhaps what I've done is it's probably my fault for expressing myself in that way. What I mean is that where they are able to form a view about the loss that they have suffered, they are entitled under this to reduce that to a sum and demand it. Now, there may then be a dispute about whether that is a demand that actually reflects the losses. But if they can come to a view that the amount that they are demanding is equal to the losses they've suffered as a result of the incompleted reorganisation, then they can make a demand for that amount. But what is essential is that it is a demand. It's not simply saying this may happen or that may happen. And of course, your lordship is right. There may be circumstances in which that simply can't be done. They can't come up with a figure. But the contractual scheme that the parties have entered into provides that a clause 11.1 claim is only one of several ways in which they can make claims. There are warranty claims, and there are the procuring obligation claims under clause 14.51.3. And the agreement between the parties is essentially that they can pursue those if they're entitled to. It's also said that it would be a haphazard scheme if there were certain circumstances where an indemnity claim could not be made because they couldn't formulate a demand, and therefore they had to make the claim in some other way. and again, we say in response to that that is not haphazard. That is just the scheme that the parties have entered into. They require a demand within a certain period in order for a clause 11.1 claim to be advanced. There's nothing wrong with that, and there's nothing wrong with them being able to pursue claims in other ways, including warranty claims or 14.51.3 claims that may be deferred in some way under paragraph 8 in circumstances where it's contingent liability or it's impossible to quantify. So there is a mechanism that allows a form of claim in respect of the reorganisation where the claim cannot be quantified. So I was going to go on to deal with, those are my submissions in relation to the demand point, and I was going to move on to the timing point. For these purposes, it is the best place to view the provisions is in Core 16, page 194, which is the digest that was produced below of the relevant contractual clauses. And I'm going to that because this is where one sees the amended provisions as a result of the deed of variation. And again, what I want to do is to just outline our basic construction case before going to the judgment. And if one goes to 194, towards the bottom of that, you can see that it says the SPA as amended by deeds of variation. So there were two deeds of variation, 30th of June 2020 and 29th of December 2020. Now, the original SPA was in 2018. By the time these deeds of variation were entered into, the issue with the deed of covenant had arisen because on the 11th of April 2019, Uniper had said that the exercise of the option was invalid. And on the 22nd of May 2019, Drax had written giving notice of matters that may give rise to a claim. And that is at supplement tab 2, supplemental bundle tab 2. It's at page 226. And it's perhaps just worth looking at the first paragraph of that. So to repeat, this is not a notice of claim. This is a notice that was required under 5.1 of Schedule 4 of matters that may give rise to a claim. And what they say in the first paragraph is we refer to paragraph 5.1. We hereby give notice of a matter which may give rise to a claim under the SPA, including but not limited to a claim under clauses 8.1, that's the warranties, 11.1, 11.6, and or 14.51.3 of the SPA. So 11.1 is what's defined as the reorganisation indemnity claim. 14.51.3 is the procuring obligation in respect of the transfer of the Damhead to Creek option agreement. So what then happened was that the deeds of variation that were entered into were entered into in the specific context that claims had been intimated in respect of Damhead Creek 2, starting from 22nd of May 2019, and they had been intimated both as warranty claims, clause 11.1 claims, and clause 14.51.3 claims. In other words, the three kinds of claim that were subsequently notified. So going back to the core bundle at page 194, so against the backdrop of these threatened claims, the parties agreed a new definition of a kind of claim. And we see that at the bottom of 194, Damhead Creek 2 option agreement claim. And so that's any claim under or pursuant to this agreement, and so on, arising out of or in connection with any failure to validly assign the benefit of the Damhead Creek 2 option agreement. And then it goes on to give more examples that are related to Damhead Creek 2 option without limitation. So that's the important definition. And just to note, this is a generally worded definition in relation to the type of claim. So it captures any claim pursuant to the agreement. But in contrast to the other definitions in paragraph 2, or the other definitions of claim in the original SPA, it is defined specifically by subject matter. So it is only relating to Damhead Creek 2 option agreement claims. Then if we go down on to page 195, this is paragraph 2 as amended, showing the amendments by the deeds of variation in red. So 2.1.1, in respect of any relevant claim, so that would cover warranty claims and the procuring obligation claim. So that sets a date of 18 months. And what you can see is that the amendment carves out Damhead Creek 2 option agreement claims from that, so that they are not subject to the 18-month requirement. 2.1.7 is claims on a reorganisation indemnity claim. And you can see that reorganisation indemnity claims had quite a sort of broad scope because there were many reorganisation documents and agreements. But what it does is it deals specifically with EHS matters, which gives it 10 years. And then there's a general provision that says claims which relate to any other matter, event or circumstance on or before the date, which is 7 years from the completion date. So under the original agreement, a clause 11.1 claim arising in relation to Damhead Creek 2 would have been made under 2.1.7. But it would have done so because of falling within the general provision under 2.1.7b. And then we have 2.1.10, which is a wholly new clause introduced by the amendments, referencing the new definition that we have seen. And we say this is the provision that applies to the present clause 11.1 claim. So in respect of any Damhead Creek 2 option agreement claim on or before the date, which is 30 months from the completion date. So the key question is the claim, the clause 11.1 claim that is now being pursued, is it in respect of any Damhead Creek 2 option agreement claim, to which the obvious answer, the only answer, is yes. And that means that 2.1.10 would apply to give a 30-month from completion time limit. And the only issue is how 2.1.7b interacts with 2.1.10. Because on their literal wording, the current clause 11.1 claim falls within both of them. But we say that applying the usual techniques of construction, the parties intended, when they entered into the deeds of variation, that all the Damhead Creek 2 claims would be within 30 months after completion. That was why 2.1.10, the new clause, was included. And there are perhaps 5 sort of points that can be made at the outset. As I've already said, when the parties amended the SPA by the deeds of variation, they didn't just have warranty claims and 14.51.3 claims in mind, i.e. the relevant claims. They had in mind any claims that might arise in respect of Damhead Creek 2, not least because the 22nd of May 2019 letter had given notice that there of matters that may give rise to a clause 11.1 claim, and that was what it was the subsequent correspondence that prompted these deeds of variation. Drax has suggested in its skeleton that the parties had no impetus to turn their minds to Drax's indemnity claim, but that cannot be right. It must have been at the forefront because the indemnity claim had been the subject of the 22nd of May letter.
If that's right, it's quite striking, isn't it, that the specific exclusion of Damhead Creek claims from relevant claims is not also applied in 2.17. It doesn't say in respect of any reorganisation indemnity claim other than a Damhead Creek claim.
Well, we wouldn't be here if 2.1.7 had a carve-out in respect of Damhead Creek to claims, option agreement claims. I'll come on to it, but it's not difficult in my submission to understand why that is the case. And the short answer is that the time limit under 2.1.1 was 18 months. So the parties wanted to extend that to 30 months. They had to have a carve-out in 2.1.1 because otherwise they would still have a shorter time limit in place, the 18-month time limit. That is not the case in relation to 2.1.7 because that is a 7-year time limit. So it is understandable to leave that as is because what the parties were doing was imposing a specific 30-month time limit. In other words, a time limit that would arise before one even got to 2.1.7 that was applicable to all the Damhead Creek claims. So that is one of the aspects. That's the looking at the more stringent criterion. But there are other aspects which I will develop. Presumably, because of the breadth of the potential claims, that presumably is the reason why they chose the breadth of the Damhead Creek to option agreement claim definition. And of course, what the parties could have done is have adopted the same approach as was adopted in the original paragraph 2. So the original paragraph 2 of Schedule 4, the taxonomy is to look at different types of claims, so relevant claims, reorganisation indemnity claims, and so on. So they could have adopted a definition of Damhead Creek 2 option agreement claims that was simply confined to relevant claims. This is in the amendments made by the deed of variation. And had they done so, it would have been clear when they referred to Damhead Creek 2 option agreement claims that they were only talking about the relevant claims. And this is not just the usual point that one sometimes makes that, well, they could have worded their bargain differently. The scheme of paragraph 2 in its original form is to take claims type by type. That would have been, I submit, the default drafting mode if the parties were only seeking to alter time limits for particular types of claim. That would have involved leaving the subparagraphs as they were, save for creating an exception under 2.1.1 in respect of Damhead Creek 2. Now, what the parties in fact did was they chose to adopt a different taxonomy of claims. They chose to adopt a definition that was not by type, but was by subject matter. And in my submission, one should infer that that was done deliberately out of a desire to capture all of the claims that were covered by that subject Drax's construction does not work without some substantial alteration in the language of 2.1.10, because as I've submitted, Damhead Creek 2 option agreement claim covers all kinds of claim. So what they need to do in order to get the construction that they want is to read down 2.1.10 so that it doesn't apply to all Damhead Creek 2 option agreement claims, but only applies to the relevant claims that would otherwise have been fitted within 2.1.1. And no doubt there's language that one could construct to do that, but my point is that it hasn't been done. And we say that the language that the parties' bargain fits with 2.1.10, essentially taking primacy over 2.1.7. And we say that for really three reasons. This is, and I'll come back, if I may, to develop these a little bit more. But what that does is it gives primacy to the amending provisions over the original language. It gives primacy to the more stringent condition, and it gives primacy to the specific provision over the general provision. And in relation to amendment, one can see that in any amendment process, the parties will be primarily focused on the amendments themselves, although any good draftsman is also going to be expected to look at the unamended provisions to see whether there are consequential impacts. But given that focus, if there is a tension that one finds between the amended provision and the unamended provisions, we do suggest, and this is no more than a common sense submission, it's difficult to reach the conclusion that the parties chose some unambiguous amendments, but they got that wording, the wording of the amending language, wrong, and that language has to be amended or substantially glossed. It's rather easier to infer that a consequential change to some of the unamended provisions was not considered necessary, or even if there is a conflict, was not focused on in making the amendments. And to some extent, this also reflects the common sense justification for giving more weight to specific provisions over general provisions, because the draftsman's more likely to have focused on provisions that are specifically dealing with the subject matter in hand than when drafting provisions that might apply to various different subject matters. Just going to, if I may, to the judge's reasoning, which is at page 140, paragraph 125. So the main reasoning is in subparagraph 1 of 125. And if I can pick it up in the middle, the amendments made were to carve out from paragraph 2.1.1 any Damhead Creek 2 option agreement claim that fell within the definition of relevant claim. They were no longer subject to 18 months, he says. Those claims that were removed from paragraph 2.1.1 were given their own time period in paragraph 2.1.10. In other words, the parties were introducing a new paragraph 2.1.10 to apply only to Damhead Creek 2 option agreement claims which were relevant claims. And so the conclusion is clear, but it does little more in this paragraph than state what the conclusion is. And what we respectfully submit is lacking is consideration of the scope of the claims that had already been intimated at this time, the breadth of the Damhead Creek 2 option agreement claims definition, the breadth, consequently, of 2.1.10, and essentially, part of our complaint is that the judge hasn't really explained here how he came to this particular conclusion, albeit that the words have clearly struck him in a particular way, and he has expressed that conclusion clearly. Continuing on subparagraph 1, at the end of the paragraph, the judge says there were no words added expressly removing any reorganisation indemnity claim from paragraph 2.1.7, nor any other indication that the parties intended to remove any reorganisation indemnity claim from paragraph 2.1.7, such as also to place such a claim within paragraph 2.1.10. So this is the one place where the judge deals with 2.1.10. But what is absent from this is any acknowledgement of the fact that the unambiguous wording of clause 2.1.10 is to cover the claim that is being made, because it covers all claims in respect of Damhead Creek, or any acknowledgement that something has to be done to the language in order to disapply 2.1.10. And it appears to have been important to the judge's decision that there was no wording in 2.1.7b to carve out an exception in respect of Damhead Creek 2. But as I've said, in answer to my Lord Justice Mayall's question, that there is a fairly understandable reason for that, which is you have to make the amendment to 2.1.1 because that 18-month timeline is coming up. You do not have to make the amendment to 2.1.7 because the 30-month time limit is going to be reached before you get to the 7 years. If one then looks at the further reasons that the judge gives, and I will come back to the arguments on the wording in a moment, what the judge deals with at subparagraphs 2 and subparagraphs 3 are essentially commercial reasonableness points. And so it's perhaps worth looking at 2 and 3. So in 2, judge says no obvious reason why the parties would have intended to shorten considerably the period for bringing a reorganisation indemnity claim. And then in 3, it says that this leads to a situation where 2 separate time limits govern the same claim. There was, in fact, good reason why the parties, or why reasonable people in the position of the parties would have wanted a single cut-off time. Drax had already threatened a Damhead Creek 2 claim, formulated in at least 3 different types. The Scottish Power would naturally want to have certainty as to whether a claim was being brought. That could only be provided by a single cut-off. Otherwise, the 30th of June 2021 could pass without notice of any claim, but Scottish Power would still have to wait until 2025 until it knew whether any claim was being advised. In circumstances where it was being suggested that essentially the same dispute could be put in a number of ways, which would make rather pointless having a cut-off date that applied to that subject matter for one type of claim but not the others. And it's not difficult to see why Drax would have been prepared to agree a single time limit. It was already in a position where it had identified the potential 11.1 claim. This wasn't a case where it was having to cater for future unknowns as to the kind of claim that might arise. And again, viewing this objectively, one can see that Drax is asking for an indulgence in one way. There may have been a quid pro quo to go the other way in relation to clause 11.1 claims, to reduce them all to a single 30-month claim. And as for the point at 1253, We do say that the judge was wrong to think that there was something unusual about having a single, having separate time limits, or rather, I'm not sure that's quite right, but essentially, the amendments, the parties did not intend to keep the same scheme of having different provisions that applied separate time limits to different types of claim. The amendments, as I've said, are a marked departure from that approach because they're by subject matter, not type. And what they're seeking to do by 2.1.10 is to have the same 30-month time limit. And so, noting that marked departure, the default position ought to have been to assume that there was a marked departure in terms of how of the effect that was intended.
Isn't it fair to say that at least at first sight, both 2.1.7 and 2.1.10 apply to
Yes.
this claim?
Yes. No, we agree with that.
Okay, sorry.
And really, the nature of my submission is that using all the tools that the court has to construe it, it is what one can see, nonetheless, that which is to have primacy over the other. And we simply submit that the judge got it wrong in thinking that it was one way, when in fact it's the other way. What I wanted to do, my lords, is say a little bit more about the three factors that I said essentially guide that conclusion, which is priority to the amending provision, priority to the more stringent provision, and priority to the specific provision over the general. And we accept that as a matter of pure language, one could say, well, 2.1.7 covers a clause 11.1 claim, and so does 2.1.10. But it does, in our submission, make a difference, and this is, again, just a common sense submission that I'm making, that the provision of that 2.1.10 is the amending provision. That is the provision that the parties must be taken to have particularly taken care over, had focus on, and they are unlikely to have drafted that and made a mistake as to how it should be interpreted. Then one of the other submissions that we made was that the stricter of two overlapping requirements should be preferred. And the judge dealt with that at paragraph 127. And the judge said there seems to be no such general principle. In some circumstances, it may be that the stricter restriction applies. In others, it may be the less strict restriction. So he didn't accept that. Now, again, this is just a question of language in its context. And what we submit is that where you have an agreement that has one deadline, and the parties agree to have a further deadline for a specific kind of claim, then as a matter of language, it's the new, shorter deadline that is going to apply. And the example that we give is the planning application. All planning applications must be submitted by the 31st of March. And then you have another provision, all planning applications for buildings over 5 stories must be submitted by 15th of March, 2 weeks earlier. So, again, as a matter of ordinary interpretation, if you've got a 6-story building, can you wait until the 31st of March? Or do you have to put it in by the 15th of March? We say, obviously, 15th of March. And that is whether or not those two stipulations cross-refer to each other, whether one says subject to this or subject to that. You don't need that mechanism in order to interpret what is being meant. And essentially, that is what we say is going on with 2.1.7b and 2.1.10. 2.1.7b is saying non-EHS reorganisation indemnity claims, 7 years. And 2.1.10 is saying Damhead Creek 2 option agreement claims that are reorganisation indemnity claims, 30 months. And again, we say fairly clear which the stricter one applies. There was also a point that only arose in relation to permission to appeal, which was the different way of putting the argument about specific and general provisions. And the judge rejected that in refusing permission. And he said it didn't, he accepted the general point that a specific clause ought to be given priority over a general one. But he said it didn't apply because one category was not a subset of the other. Again, in my submission, if one looks at 2.1.10 and looks at 2.1.7, it is clear that we are dealing with one of these cases where you have a general provision and you have a specific provision. And that, again, is a third factor towards prioritising 2.1.10. And essentially what the judge said is, well, 2.1.10 is not just talking about reorganisation indemnity claims because it's drafted to cover relevant claims, and therefore it's not a pure subset of 2.1.7, which is only concerned with reorganisation indemnity claims, and therefore this is not a case of the strict of the specific taking priority over the general. And I should say, I'm not relying on this as some form of presumption. This is just an aspect of the ordinary approach to construction, albeit one recognised in Lewison, and we've put that in the authorities at tab 15 in the latest 8th edition. But the right analysis, if I can put it in two ways. First of all, when you look at 2.1.10, what that is covering, if you expanded it, is a Damhead Creek warranty claim, a Damhead Creek 14.51.3 claim, a Damhead Creek reorganisation indemnity claim, and it's saying 30 months. The only bit of that provision that we're concerned with is to do with the reorganisation indemnity claim, because that's the only bit where there's any contest of competing time limits. There's no contest for the warranty claims or the others. So once you have once one just does the mental breaking down of 2.1.10, on the issue that matters, it's just a case of one provision, 2.1.10, that is a subset of the other, because the relevant bit of 2.1.10 is those reorganisation indemnity claims that are specific to Damhead Creek. And it is therefore a subset that ought to take a specific provision that ought to take precedence over the general. And there is a slightly broader way of looking at it, which was if you take the original paragraph 2 provision, that is in one sense, a general provision that is dealing with time limits for all types of claim. If you look then at the two deeds of variation, those are specific provisions because they are only dealing with Damhead Creek 2 option agreement claims. So if one is trying to identify where is the specific, where is the general, one way of looking at it is, well, 2.1.10 that is introduced by the deed of variation is coming from a deed of variation that is all about a specific subject matter, whereas the original paragraph 2 is about all subject matters. So for those reasons, we respectfully submit that although you have this position where literally it could fall within 2.1.7b or 2.1.10. On a proper construction, there are many pointers, many indicia in the agreement that points to 2.1.10 being the more having primacy, and that really just leaves contra proferentum, which is dealt with by the judge on page 141, paragraph 125.4. And what the judge there says, he referred to the Hutt group case, which explains the modern approach to contra proferentum, and says to the extent there is ambiguity about this, there is scope to resort to the principle that they should be construed narrowly. So it doesn't appear that the judge placed much weight on questions of contra proferentum or the modern approach to it. But at any point, the judge referred to the Hutt case in his judgment, and we don't need to go to the underlying judgment. The critical point from it is that one only has resort to the modern approach to contra proferentum as an interpretive tool of last resort, applicable only where a conclusion cannot be reached after using all the usual linguistic, contextual, and purposive tools at the court's disposal, and we've referred to that in paragraph 48.2 of our skeleton at page 16. And so that also does not mean that if one can identify an ambiguity, that suddenly one resorts to questions of narrow construction. Before one does that, one tries to use all of the linguistic and interpretive tools in order to reach a conclusion, and only if that fails does the principle become engaged. I would also say it's a highly context-dependent principle, even where it does apply, because where it does apply, one is looking at the nature of the rights that might be taken away by the less strict construction. And here, we're not concerned with some sort of common law right that is being taken away, but rather it's a specific covenant to pay that's created by the SPA. But perhaps more importantly, in terms of what is being taken away, or what would be taken away, as of the deeds of variation, Drax knows that there is an issue with the deed of covenant. It's already threatened a claim under clause 11.1. It has all the information it needs in order to make a claim, because it's making the claim now in the amended particulars on the basis of a historical loss based on diminution. So if one asks the question, in those circumstances, is there much being lost by saying, well, actually you've got 30 months for all these claims, not 30 months for some, 7 years for the indemnity? Well, the answer is not very much, because this is not talking about some potential future unknown claim. This is actually the claim that they have already intimated and are going to have to make on any view within 30 months in the other ways in which they are formulating the claim. My Lords, those are my submissions in relation to the indemnity appeal, and we respectfully submit that the correct construction is that 2.1.10 prevails.
Thank you very much, Mr. Hussain. Mr. Quest.
My Lord, we're going to divide the indemnity claim response. Mr. Hinks is going to deal with the demand point, and then I will deal with the time. That's acceptable.
My Lords, the demand issue raises a short point of construction. The issue, as my learned friend has explained it, is whether the claimant can notify a reorganisation indemnity claim before the claimant has made a written demand for payment of an ascertained sum under Clause 11. He says that that can't happen. On his construction of these provisions, no reorganisation indemnity claim arises and the claimant has nothing to notify the defendant of unless and until a demand has been made. We say the judge's decision on this issue was correct. Under the regime that was agreed between the parties, the claimant was entitled to notify a reorganisation indemnity claim before a demand for payment had been made. We make 5 points in respect to this issue. The first point is that the language used in the SPA supports the claimant's construction, that one can notify a reorganisation indemnity claim before a demand has been made. The notification clause requires the claimant to notify the defendant of any reorganisation indemnity claim within a specified period of time. A reorganisation indemnity claim under the SPA is defined as a claim pursuant to Clause 11.1. Looking at Clause 11.1, which is on page 52 behind tab 1 in the supplemental bundle, we say that there are 2 aspects to it. Firstly, the parties agreed that the defendant will be liable for an amount that is equal to losses falling within the scope of any of the subparagraphs. And secondly, the parties agreed that that amount will be payable 5 business days after a written demand has been made. We suggest that there was nothing stopping the claimant from notifying the defendant of a claim under this provision at the time that the notice was given in June 2021.
What is the claim?
Pardon me?
What is the claim? Is the claim the fact that you've suffered loss, or the fact that they haven't paid after 5 years? 5 days.
Well, what we're notifying of is that there is going to be a claim under this provision. And we are entitled, we say at that stage, at the time that the notice was given, to give such notification because it was clear by that point that the option to acquire the easement hadn't been effectively assigned to the company, and therefore losses had been suffered and were likely to be suffered, falling within the scope of these paragraphs. If one steps back and asks, at that stage, has the defendant incurred a liability to the claimant under this provision? We say the answer to that is yes. That liability a company lawyer might call that liability a contingent liability or a prospective liability. But either way, by that stage, the defendant had incurred some form of liability to the claimant under Clause 11.1. And we say that the natural corollary of this is that the claimant had a claim pursuant to Clause 11.1, which was at least capable of being notified. And the fact that an ascertained sum might not become payable until after a written demand was made under the provision doesn't, in my submission, affect that analysis. And in any event, even if the claimant's cause of action pursuant to Clause 11.1 was legally incomplete at the time that the notice was sent, in the sense that an ascertained sum was not by that stage payable, it doesn't follow that the claimant was precluded from giving notice of a claim pursuant to clause 11.1 to the defendant. Going back to the notification wording, there's nothing in my submission in the language of paragraph 2 which suggests that the claimant can only notify claims where the cause of action has by that stage, by the time of the notice, fully accrued in its favour. There's no requirement that on the date the notice is given, the claimant needs to have a fully fledged cause of action under clause 11.1. The only requirement is to provide specified information.
That's true, Mr. Allen, but if the answer to my question is that a claim under paragraph 11, section clause 11, is a claim for the failure to pay after 5 days, then there isn't such a claim until you've made the demand. If the answer to my question is, on the other hand, the losses, then it could be. That's why I asked.
So we would obviously say that it's the latter, my lord.
But then that is quite an unusual way of putting it, which is that it's the latter. The claim is the claim for losses that you are due to make good. If you look at paragraph 11, I can't remember the page number, is it 56? 52.
52.
Covenants to pay. I mean, because clause 11 is a really odd clause. It just says you covenant to pay the buyer within 5 days of a demand in writing any and all losses suffered by the company in relation to certain matters. So it wouldn't be the natural use of language, would it, to say that the claim is the losses suffered by any and all by group company in relation to certain matters?
Well, as I said, my lord, we say that there are two aspects to this. There is a promise to pay an amount which is equal to losses suffered, and there is the payability aspect to it.
Well, that's true, but not relevant to the point I'm asking you about, which I think is important, because it gets to the heart of whether you can. You obviously can't notify a claim that doesn't exist, right? I mean, you'd agree with that. I mean, the clause is not saying notify that you might in the future have a claim, because clause 8 deals with that. Paragraph 8, I can't remember.
Well, we'll come on to paragraph 8.
But I mean, it's not saying, is it? You can notify a claim that doesn't exist. So there has to be a claim under paragraph 11. And
we say it is sufficient that by the time that notice is given, we have suffered a loss. So a loss has been suffered.
right, but then you're answering my question as you said you were. Yeah. But it's sort of an odd use of language.
Put it this way. Suppose by the time that hypothetical notice is given, by the time the notice is given, the company has paid to acquire the rights from Uniper. No demand has been made. No written demand has been made. But the notice says we've acquired these rights. It has cost the company £5 million.
Losses.
And we're going to make a demand for that amount in the future. We're giving you notice that that claim is going to be made, and there might be other losses associated with this as well.
That's your point, really, is that it doesn't have to be a crystallised claim.
Right.
But does it have to be a cause of action?
Well, in my submission, there's nothing in the language of the notification provision which requires that.
Because there's two causes of action also, as well as claims. There's a cause of action that arises in contract for breach of the warranty or breach of the statement or whatever it might be, which is complete without damage.
Yes.
And then there's the cause of action under 11 for failing to pay the amount claimed, which is completely different.
I see that.
So which is the claim?
Well, we say provided a loss has been suffered that falls within one of those subparagraphs.
Yes, but you see my point. You can have the first one, and that's fine, and you can make intimate a notice of it. But how? I'm just really asking for help. How do you have the second one, and how do you have a cause of action or a claim or anything meaningful for failure to pay a demand that hasn't been made?
I think what it would come down to is what the claim is that one is making.
Yeah.
So, if one is claiming an ascertained sum, and I'm using claiming in a legal sense now. If I'm issuing a claim for an ascertained sum, then I would need to have made a demand for that in order to get that claim off the ground. But if I'm issuing a claim for an indemnity under this provision in respect of losses falling within the scope of clause 11.1, when those losses have been ascertained.
I mean, I get all that. My problem with clause 11 is that a claim under clause 11 doesn't make much sense, because actually all clause 11 says, and I have to keep on going back to it because it's eminently forgettable, but all it actually says is a covenant to pay.
Yeah, within a period of time.
So, claim under a clause that has a covenant to pay doesn't make much sense unless you haven't paid, I suppose. I think that's the better point, perhaps.
I was going to move on to my second point.
Yes, very sensible.
which is this textual analysis accords with what these sophisticated commercial parties are likely to have intended. It's likely that the parties would have intended that reorganisation indemnity claims would be capable of being notified when it was known that a loss falling within the scope of clause 11.1 had been suffered. That accords with the purpose behind these clauses, to give the parties a heads up, to allow them to investigate and gather evidence. It's less likely that the parties would have intended that the claimant would be precluded, would not be able to notify a claim unless and until a written demand for an ascertained amount has been made. It's just counterintuitive in my submission to suppose that the defendant wouldn't want to be given notice of any such claim until after a demand has been made, at which point it only has five days before it's liable to make payment. My third point is that the judge was right to reason in support of his conclusion that the defendant's construction would lead to uncommercial results, which the parties are unlikely to have intended. His point, which was at paragraph 116 of his judgment, was that if the defendant's construction is correct, a reorganisation indemnity claim could only be notified after the claimant is able to ascertain the amount that is payable under clause 11, with the consequence that if the claimant is unable to ascertain that amount within the applicable notification period, the claim could never be brought. And we say that as sophisticated commercial entities, that's not an outcome that the parties are likely to have intended to create. If the circumstances were such that losses falling falling within the scope of the indemnity provisions have been incurred, but those losses were not at that stage capable of being quantified, the parties are unlikely to have intended that the claimant would simply be shut out from making a claim under this provision. And in response to that, my learned friend and Scottish Power says that there's nothing preventing the claimant from coming up with a figure and demanding that figure and then notifying the defendant of that claim, the failure to pay that figure, and if the defendant refuses to pay and the court later concludes that the claimant is entitled to that figure or a lower figure but not a higher figure, it appears, then the defendant will be liable to pay that amount. But we say it's just unrealistic to suppose that the parties intended that their agreement would operate in that arbitrary kind of way. It doesn't serve any real commercial purpose for the claimant to need to put an arbitrary figure, a high one, on its claim in order to notify the claim and to get it off the ground. And the second point that
is it uncommercial to agree that if you can't come up with a figure within 7 years, then you don't have a claim? And that seems quite a sensible limitation provision in some ways.
Well, the first point to note is that, of course, the defendant says that the period is much shorter than that, and that the period is in fact 30 months. So if you can't come up with...
Yes, but one is looking at clause 11 and seeing what that means, which was before the deeds of amendment had even been thought of. It talks about making a demand. I'm just questioning whether it's given a very generous time limit for this particular category of claim, whether it is as uncommercial as you suggest to say that if you can't come up with a figure, then that's the end of it.
Well, if a genuine loss has been suffered, falling within the scope of these provisions, but it just so happens, and it's difficult to think of the circumstances, and there could be many, but if the circumstances are such that by the end of a 7-year period, it's just incapable of being quantified, one can't put one's finger in the air and pull out a number, then it's a valuable right, but absent clear wording, the parties are unlikely to have intended that the claimant would simply be shut out and wouldn't be capable of notifying or bringing that claim. The other point that the defendant makes is that clause 11 is only one part of the liability regime. My learned friend says that there are other claims available, and we've advanced those claims, warranty claims, and the other breach of contract claims. But we say it's unrealistic to suppose that the parties intended that their agreement would operate in that kind of dysfunctional way. It's common ground between us that whilst the same events might give rise to different claims under different provisions of the SPA, the remedies are not necessarily the same. And absent clear words, it's unlikely in my submission that the claimant would have intended to give up potentially valuable rights under clause 11 simply because it might have other rights available under different provisions of the SPA. My fourth point, my lords, is that paragraph 8 of Schedule 4, which we looked at briefly earlier, which is on page 105 in the supplemental bundle, is not informative of the answer to this demand issue. It concerns claims which are contingent only or not capable of being quantified, but it's common ground that this provision is of no application to reorganisation indemnity claims, and for that reason it doesn't particularly illuminate how or when a reorganisation indemnity claim is to be notified. If anything, we say that the existence of this provision supports the claimant's construction. We say that all this provision does is to extend the 6-month period for commencing claims, for legally commencing claims, issuing and serving them, which are relevant claims under paragraph 3 of Schedule 4, and it extends that period to the day on which the claimant actually suffers the loss. What the provision doesn't do is to create an entitlement to notify a contingent relevant claim where no such entitlement otherwise exists. What paragraph 8 does when it's dealing with the notification issue is to deal with it in a passive way. In Roman numeral 1, it says that the buyer will not be prevented from notifying under paragraph 3 of this schedule. And what we take from that is that the parties intended that generally any contingent claim would be capable of being notified under paragraphs 2 and 3, but that as regards relevant claims, as Roman numeral 2 provides, and this is really the operative part, the meat of this provision, the 6-month period for issuing and serving such claims would be extended to the day on which the loss is suffered. And a possible justification for that would be that the notification period for relevant claims is 18 months. It's the shortest of them all, so it's more likely that one would have contingent relevant claims that haven't worked themselves through. The contingencies haven't become realised, than would be the case for the other types of claim, where the notification period is 7 years. And my fifth and final point, my lords, is that the notice was adequate to notify the defendant of the reorganisation indemnity claim. The only point that's taken is the absence from the notice of an ascertained sum. We say that the judge was right to conclude that the notice gave reasonable detail of the amount claimed in respect of the claim under clause 11.1. There's no requirement under paragraph 2 of Schedule 4 to give notice of an ascertained amount, particularly in circumstances where the full extent of the losses have not been quantified. And it was sufficient for the claimant, as it did, to set out what losses were likely to be suffered, giving such figures as the claimant was able to give. And that approach satisfies the commercial purpose of the clause in letting the defendant know what it was up against. My lords, unless I can assist further.
Thank you very much, Mr. Allen. Mr. Quest.
Yes, my lord, I will deal with the timing point, which of course only arises if we're wrong on the preceding point. It may be convenient just if you can have again in front of you page 195 of the core bundle, which has the notice clause as amended. And your lordships have already seen, I think, how the difficulty arises, which is we've got clause 2.1.7 with a 7-year time period for reorganisation indemnity claims, and clause 2.1.10 with a 30-month period for Damhead Creek 2 option agreement claims. The complication being that the set of Damhead Creek 2 option agreement claims overlaps with the set of reorganisation indemnity claims, by which I mean any particular claim could be one or the other, or both, or neither. And the particular claim that we are concerned with is a claim that is both a Damhead Creek 2 option agreement claim and also a reorganisation indemnity claim. And so on the face of it, as my Lord Justice Birss said, appears to fall within both 2.1.7 and 2.1.10, and in one way or another, one has to be given priority.
Well, the irony is that if the answer to my question about what is the claim under 11 is the one that Mr. Allen did not want me to use, namely that it's the first claim after a demand is made, it's obvious that there'd be a different time limit for that.
I see that. But it's Mr. Higgs.
I mean, that's right, isn't it? I mean, do you agree with that, or don't you adopt that? Because you still don't you still succeed even if you lose your first point. If Mr. Allen loses his point.
Mr. Hinks.
Mr. Hinks.
Oh, Mr. Hinks, I'm sorry. I'm so sorry. So sorry. I really am sorry.
No.
But anyway, isn't that the point?
If we're wrong on the first point.
Yeah. Mr. Hinks is wrong.
Mm-hmm.
Then it's obvious that there's a different claim under 11.
Yes, I see that. And therefore we'd then be right on this point.
Yes.
Yes, that's right. Your Lordship is right. Okay. So, well, we would take that point, and in addition, the point that I'm now going to raise.
You'll bang that one.
Yes, it were.
We may have to give Mr. Hussain an opportunity just to come back and say, well, that's not.
But in addition to that, and of course this is the way the judge saw it, and is the subject of the only subject of Mr. Hussain's appeal. If one has a claim that appears to fall on the face of it within both sections, there has to be some way of resolving that conflict. What I was just going to do is just explain how the judge approached this, and then address, I think it was the 3 points that Mr. Hussain raised. The judge gave, it's set out in paragraph 125 of his judgment, quite a number of points, but I just want to boil them down, if I may, to focus on two of them. And the first point that he relied on was the fact that that this conflict, or this apparent conflict, arose as a result of an amendment to the SPA, because as we know, prior to the amendment, any Damhead Creek claims that were not reorganisation claims had an 18-month notification period under paragraph 2.1.1. But the effect of the amendment was to carve out those claims and to give them a longer period, initially of 24 months, and then by further amendment 30 months. Now, the judge said that there was a good commercial reason for extending the period for giving notice of those claims. And one good commercial reason is those claims were about to expire. And it's worth noting that the initial amendment, which was the initial variation, which was on the, which is tab 3 of the supplemental bundle, was dated 30th of June 2020, which was the last day of the 18-month period under clause 2.1.1. And we can infer, I think, must have been negotiated into the run-up to that date. So insofar as there were what we now call Damhead Creek 2 option agreement claims within 2.1.1, because they were not reorganisation claims, those claims were on the point of expiry. And if an extension had not been agreed, then no doubt Drax would have felt the need to put in a protective notice of some kind. So one can quite see from a commercial perspective why the parties, as parties often do in these situations, agreed a relatively short extension for those category of claims. On the other hand, the time period for, and this is the way the judge saw it, the time period for reorganisation indemnity claims generally was at that time long in the future. It was still some 5 years away. And there was no obvious commercial reason why Drax would have agreed to significantly shorten the period for reorganisation indemnity claims, just because it so happened that they were also Damhead Creek option agreement claims. Not least because on the relevant premise for getting into this timing question in the first place, it was necessary, the defendant says, for Drax to specify the precise amount claimed when it made a notice, which might well be problematic back in 2020 because there was still uncertainty about the cost of obtaining an easement and so on. So it seems highly unlikely from a commercial perspective that Drax would have had any incentive to significantly shorten the time period. And just as a general matter, it's of course commonplace in disputes for parties to agree extensions of time for steps to be taken, particularly if the time period is about to run out, and one or other party might otherwise have to take a protective step. But comparatively rare for parties to agree to shorten time for things they have to do. And the defendant's construction of this clause would involve Drax subjecting itself to serious additional time pressures for notifying certain reorganisation indemnity claims, i.e. those that were also Damhead Creek option agreement claims, beyond those that it had originally agreed in the contract, that had cut down the 7 years that it had initially negotiated for itself. And the judge was right in my submission to regard that as a very important factor in the interpretation of this provision. The defendant says, well, actually, there is a commercial rationale for shortening, both lengthening some of the Damhead Creek claims and shortening the others. It says the commercial rationale was to create a single deadline for all types of claims arising out of the option so that the parties knew where they stood. But the idea of having a single deadline is not something that's supported by any evidence. It's not something that one can read out of the agreement. It's unrealistic, as I say, to suppose that Drax would agree to cut down its notification periods. And perhaps most significantly, the scheme of having different notification time periods for different types of claims was a scheme that was in the contract from the outset. So there's nothing surprising about the fact that the parties chose to continue with it. And it's a sensible scheme, given that all these different kinds of claims that we see in paragraph 2 attract different kinds of remedies. So that was the judge's first point, which was the sort of commercial considerations when one looks at the timing of the amendment supported the view that clause 2.1.10 was not to be seen as cutting down 2.1.7.
So if we look at Lord Justice Lewison's book at page 242 in the authorities bundle, he says where a contract contains general provisions and specific provisions, the specific provisions will be given greater weight than the general provisions, where the facts to which the contract is to be applied fall within the scope of the specific provisions. Is that right or wrong?
I would not necessarily disagree with that in principle, and the judge referred to that. The answer to that, which indeed is the answer the judge gave, is this is not a case of specific provisions and general provisions. Neither 2.1.7 nor 2.1.10 is a special case of the other one. And Damhead Creek 2 option agreement claims are not a special case of reorganisation claims or vice versa. They are, as I say, overlapping types of claims. And one can't look to any one or the other to say one is more specific than the other. Because
well, I mean, the one arises out of the other because they were an amendment to the other.
Well, no, in terms of the claims, you've got a provision that deals with reorganisation indemnity claims, and you've got a provision that deals with Damhead Creek option agreement claims, some of which may be reorganisation indemnity claims, and others will not be reorganisation indemnity claims. So this is not a contract. I would see the force of the point if 2.1.10 was dealing exclusively with a subcategory of what 2.1.7.
But all the Damhead Creek 2 option agreement claims, which I find impossible to say, but I've just said it, all those are also some other kind of claim under the agreement. Because they only arose by way of variation after the
Right,
Downhead
but
Creek
they-
2 option agreement problem had arisen.
Your Lordship's right, but they are not all reorganisation claims.
No, I get that.
They are, in fact, they are either capital R relevant claims,
No,
or
there could be
reorganisation.
lots of things, but all I'm putting to you is that this surely could be used to say every claim that is a DC2 claim is covered by it.
Well,
If my point that I put to you is wrong.
yeah, but that doesn't follow from, as I say, from the principle or how I want to put it in Lord Justice Lewison's book, because we're not dealing with a special case of a general case. We're dealing with two different sets of claims.
Okay, all right.
Which
I don't
overlap.
want to-
But we're not. I mean, that's
I don't want to delay you. I'm sorry. I'm just
no, but it's an important point, because in some ways that's the main point that the defendant makes in response, to say, well, when one looks at this, it's clear that 2.1.10 is a special case. But in a sense, it's no more. It's been added by amendment, but it's no more special in that sense than 2.1.7. It's just categorising the claims in a different way. And as the judge said, I mean, one of the reasons that this needs to be interpreted is this clause was originally drafted very sensibly so that each paragraph was mutually exclusive, and therefore any one claim would fall within one or other, exactly one paragraph. The problem with the amendment of it is it's got away from that, and it's created two clauses which are overlapping in terms of their scope. But as I say, it's not created a situation where one is a special case of the other. It's created overlapping ones to which one has to give priority. And the judge's approach was to, first of all, to give priority based on what I've already said about extending and shortening time and the commercial aspects of that. But secondly, to say that if that didn't answer the question by itself, that one can deploy the rule in Hut Group, which is to resolve the ambiguity in favour of Drax, because we are dealing with clauses which cut down Drax's ability to make a claim. So that's the way the judge's reasoning was rather more extensive than that, but that's the way in which, in my submission, the two main points that he made. In response to that on the appeal, the defendant stresses various points. First of all, they say primacy of the amendment. So they say, well, because 2.1.10 was introduced by amendment, it must have primacy. But in my submission, the mere fact of it being an amendment is at best neutral. I mean, it can be said, I think it is said, against me, that the parties did not take the opportunity when amending of carving reorganisation indemnity claims expressly out of 2.1.10. Therefore, I think it said, well, it must have been intended to include them. On the other hand, they did not take the opportunity when amending of carving Damhead Creek 2 option agreement claims out of 2.17 either. So one can't, in a sense, in the end, read anything from the amendment other than by the amendment, the parties have created the problem that the court now has to resolve. The mere fact that 2.1.10 is in red ink and there's no red ink been introduced in 2.1.7 doesn't tell you anything about which should have primacy. The second point that was made by the defendants is the one we've just been discussing, which is the specific taking precedence over the general, and that I hope I've covered already. That kind of principle applies where where something is genuinely a special case of something else. It does not otherwise apply where you've got two general clauses which overlap. Nor in my submission is it an answer. in that respect to say, well, the facts that may give rise to Damhead Creek claims may be a narrower set of facts than the kind of facts that might give rise to reorganisation claims. That may be true, but that equally one can say that from a legal perspective it's reorganisation indemnity claims that's a narrower category, because reorganisation indemnity claims are limited to one particular type of claim, i.e. claims under 11.1, whereas Damhead Creek 2 option agreement claims cover a broader range of claims, not just indemnities, but also claims for breach of warranty. Again, underlying the point that it's not really possible to say either category of claim is a special case of the other. They are categories of claims that have been formulated in different ways. One has been formulated by reference to as it were, a factual scenario, which is things connected with the option, and the other has been formulated by reference to the legal type of the claim, in other words, claims under 11.1. So we say the special versus general, or special taking precedence over general, isn't the answer, or isn't the answer to the judge's point. And then the next point taken by the defendant is it said, because there are two time limits, the stricter time limit should take precedence over the less strict time limit. But there, I think that was put forward not as a rule or principle, but just it was said as a matter of common sense. But it's certainly not the case that there's anything in any, as far as I'm aware, in the textbooks or the cases that suggests that there should be any preference for shorter time periods rather than longer ones. On the face of it, that kind of approach runs contrary to the principle in Holdco, because it gives precedence to the time limit which is more exclusionary rather than the one which is less exclusionary. And the example that the defendant gave, I think, of planning rules, set of planning rules, one that applies to tall buildings and one that applies to residential buildings. And if you've got a tall residential building, which rule do you apply? It seems to me common sense doesn't point to either one. One has to look, as the judge did, at the broader commercial considerations of the contract. Certainly not either as a matter of common sense or as a matter of commerciality must you necessarily take the shorter period. I mean, there's really no logic in that at all. And I think the final point that was raised by the defendant concerned the application of the rule in Holdco. The preference. It's called. It mentions as contra proferentum. Of course, the modern approach is not to see it like that, but as Lord Justice Briggs said, to draw the inference from the fact that parties don't lightly give up their rights. And the judge, in my submission, applied that properly and appropriately, in the sense that he came to a decision based on the construction of the clause in our favour. He then went on to say that if he was wrong about that and there was any ambiguity remaining, that ambiguity at that stage could be resolved by application of that principle. And that, in my submission, was a conventional and entirely proper way to deal with it. So, for those reasons, we say that the judge's decision on timing should be upheld for the reasons he gave.
Still have a reply.
I still have a appeal. I still have a reply. Shall I deal with that?
Yes.
Now? Yes.
I think so.
There are only a very small number of points I
was hoping you'd say that.
Just first of all, Mr. Hussain, at some points in his submission, posed the question about whether a reasonable reader of the notice would have understood from the notice that a claim in diminution in value was being brought, or whether the reader would conclude that it was an indemnity claim. As I think was discussed in argument, in my submission, that's not the ultimate question here, not the relevant question here. The question is whether the nature and the amount of the claim now being pursued was adequately stated in the notice. And provided that you've adequately stated the nature of the claim and the amount of claim in the notice, you can then subsequently plead and pursue any claim that has that nature. As regards the notice provisions, and going back to paragraph 2, it is, I think, important to bear in mind that there are two aspects to the notice under paragraph 2, the nature of the claim and the amount claimed. They are separate factors. I've already dealt, I think, at some length with what the nature of the claim means. I wasn't going to say anything more about that. On the question of amount, I did just want to come back on a couple of points Mr. Hussain made. First of all, if we just look at what's outside the brackets, in other words, a reference to the amount claimed, I understood one of the points that Mr. Hussain made was that the notice was defective because properly read, it didn't actually claim any amount at all because they were all future losses. The first point to make about that is that that's not the way the judge put it, and there's no respondent's notice. The objection that the judge had, which is at paragraph 98 of his judgment, was not that there was no amount stated at all, but that what the notice didn't do is explain that the amount represented the diminution in the value of the share. We would say that's not really a point that's open to the defendant. And secondly, in terms of the amounts, we do say it was adequately stated in the notice, and indeed as a numerical matter, the numbers that we see in the notice are exactly the same numbers that now appear in the particulars of claim, with the sole difference that I think there was a reference in the original notice to the cost of a possible compulsory purchase order, which is not now pursued. But subject to that, it is the same numbers, it's the same amounts, and therefore we say the amount claimed in the particulars of claim was also properly stated in the notice of claim. And then, and then this is my final point of this, if one then turns to the bracketed part, detailing the buyer's calculation of the loss thereby alleged to have been suffered, again, it is significant in my submission that the parties chose to use the word calculation in this provision, and not, for example, explanation or basis or a word of that character. The word calculation, I suggest, conveys an exercise which is mathematical or numerical in nature, rather than legally analytical or explicative. And on that basis, we say there was a calculation of the loss alleged to have been suffered in the notice, in as much as the numbers which go to make up the amount we're claiming were fully set out. And that, in my submission, is sufficient to comply with this clause. That's all I was proposing to say by way of reply on this. Anything else?
Mr. Hussain, do you want to, thank you very much, Mr. Quest, do you want to say anything about the question I asked Mr. Quest, because I didn't ask you?
My Lord, I wanted to say one thing before that, then address that, which is not a submission, but simply to note that one of the issues we have also raised is the declaration and whether or not the judge should have removed that. We don't have anything to say about that beyond our skeleton. I just didn't want your lordships to, as it were,
we won't lose sight.
Lose it because it hadn't been the subject of all submissions. My Lord, my confession, I'm afraid, is that I am not sure that I had understood properly the point that you were putting to Mr. Hinks and then to Mr. Quest. So, in order for me to say anything
let me ask you again.
You would have to try it on me again, and I apologise that you're having to do
it's very difficult, really. It's just that the reorganisation. Sorry, I can't remember the.
The reorganisation indemnity claim.
Reorganisation indemnity claim is defined as a claim under 11. A claim under 11 must have some meaning. What is a claim under 11? It could be two things, it seems to me. It could be the losses that you warranted you'd pay if demanded, or it could be the failure to pay after 5 days what was demanded. If it is the latter, and I'm afraid I'm putting it the other way round to the way I put it before, if it's the latter, then it's fairly obvious that that is a different kind of claim from any kind of damhead claim envisaged by the amendment agreement with a different limitation period. It's obviously a Clause 11 claim, because and a Clause 11, a reorganisation, whatever the name is, claim, because it's a special claim, indemnity claim, which only arises once the claim is demanded.
My lord, I would say I would have to disagree.
Yes, I'm sure you
and
disagree. That's why I'm giving you the opportunity to do so.
And really, what it comes back to, it's the subject matter. It's the subject matter description. So you have the claims under the reorganisation indemnity. It's all about the incomplete reorganisation.
It's a subject matter description.
It's a subject matter distinction.
Yes.
So again, if one looks back at what the definition of Damhead Creek 2 option agreement claim is, and ask yourself, that is any claim
That covers everything.
arising in connection, quite wide language.
Yeah, covers it.
So that covers everything. So it doesn't matter that what's
Whether
happening
it's-
is a demand that hasn't been paid. What matters is where that demand.
Too clever by
came
half is
from
your
and was
answer,
based
really,
on.
Mr. Hussain.
But other than that, my lord, I had no reply on the indemnity appeal.
Thank you very much. Thank you both, and thank your juniors as well. And I apologise profusely to Mr. Hinks. I actually, Mr. Hinks, looked you up on my eyesight must be so bad that I looked you up to make sure you were who I thought you were, and you weren't. I completely apologise. It's a terrible thing of sitting here on the bench. We will take time to consider our judgments, and when we hand them down, you will use them only for the purposes of agreeing an order and costs, and not for any other purpose were you to do that, but I now know that you will be aware of that. We will have any submissions on those questions if you can't agree them in writing, and there'll be no need for anybody to attend because the hand down will be remote. But may I say, even though it was a warranty claim, what an enjoyable and interesting argument you've made of it. Thank you.
Right.